For paragraph 3 of the Rules of Court, to hear the oral observations of the parties on the request for the indication of provisional measures submitted by the Republic of South Africa in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. The Court does not include upon the bench a judge of the nationality of either party. Accordingly, both parties avail themselves of the right, under Article 31, Paragraph 3 of the statute, to choose a judge ad hoc. South Africa has chosen Judge Dikgang Ernest Moseneke, and Israel, Judge Aharon Barak. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, that same provision applies to judges ad hoc. Before inviting Judge Moseneke and Judge Barak to make their solemn declarations, I shall first, in accordance with custom, say a few words about their careers and qualifications. Judge Dikgang Ernest Moseneke, of South African nationality, has had a distinguished career as a judge, law practitioner, and academic. After obtaining degrees in English, political science, and law from the University of South Africa, he practiced as an attorney and an advocate with the Pretoria Bar. In 2001, he was appointed a judge on the High Court in Pretoria, and a year later, he became a judge on the Constitutional Court of South Africa, where he was Deputy Chief Justice for more than a decade and Acting Chief Justice in 2013 and 2014. Judge Moseneke is also an honorary professor in the Department of Jurisprudence at the University of Pretoria and has served as a Chancellor of the Pretoria Technikon and the University of Witwatersrand in Johannesburg. Judge Moseneke has received numerous honorary doctorates and awards. I shall now say a few words about the career and qualifications of Judge Barak. Judge Aharon Barak, of Israeli nationality, has had an eminent career as a judge and law professor. He holds a PhD in law from the Hebrew University of Jerusalem and served as the Dean of the Faculty of Law of that university between 1974 and 1975. He was appointed to the Israeli Supreme Court in 1978 and served as its president from 1995 to 2006. Prior to joining the Supreme Court, Judge Barak served as the Attorney General of the State of Israel between 1975 and 1978. He has taught law in a number of law schools, including Yale University, the Hebrew University of Jerusalem, and the Reichman University in Herzliya, Israel. Judge Barak has also written extensively in law and has received numerous honorary degrees and awards. In accordance with the order of precedence fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Judge Moseneke to make the solemn declaration prescribed by the statute, and I request all those present to rise. Judge Moseneke, you have the floor.
I solemnly declare that I will perform my duties and exercise my powers as a judge honorably, faithfully, impartially, and conscientiously.
I thank Judge Moseneke, and I now invite Judge Barak to make the solemn declaration prescribed by the statute. Judge Barak, you have the floor.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and consciously.
I thank you, Judge Barak. Please be seated. I take note of the solemn declarations made by Judge Ad hoc Moseneke and Judge Ad hoc Barak, and I declare them duly installed as judges ad hoc in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. I shall now recall the principal steps of the procedure in the present case. On 29 December 2023, the government of South Africa filed in the registry of the court an application instituting proceedings against the State of Israel, alleging violations by the latter of its obligations under the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. I shall refer to this convention as the Genocide Convention. To found the jurisdiction of the court, South Africa invokes Article 36, Paragraph 1 of the Statute of Court and Article 9 of the Genocide Convention. South Africa states that its applications concerns acts threatened, adopted, condoned, taken, and being taken by the government and military of Israel against the Palestinian people, a distinct national, racial, and ethnical group, in the wake of the attacks in Israel on 7 October 2023. South Africa contends that the acts and omissions by Israel of which it complains are genocidal in character because, I quote, they are intended to bring about the destruction of a substantial part of the Palestinian national, racial, and ethnical group, that being the part of the Palestinian group in the Gaza Strip, end of quote. South Africa asserts that the relevant acts are attributable to Israel, which has failed to prevent genocide and is committing genocide, and which has also violated and continues to violate other fundamental obligations under the Genocide Convention. The application contains a request for the indication of provisional measures pursuant to Article 41 of the Statute of Court and Articles 73, 74, and 75 of the Rules of Court. According to South Africa, I quote, provisional measures are necessary in this case to protect against further severe and irreparable harm to the rights of the Palestinian people under the Genocide Convention, which continued to be violated with impunity. South Africa requests that the court indicate provisional measures to protect and preserve those rights, as well as its own rights under the Convention, and to prevent any aggravation or extension of the dispute pending the determination of the merits of the issues raised by the application. End of quote. The registrar will now read out the passage from the request specifying the provisional measures which the government of South Africa is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Madam President. I quote, 1. The State of Israel shall immediately suspend its military operations in and against Gaza. 2. The State of Israel shall ensure that any military or irregular armed units which may be directed, supported, or influenced by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation referred to point 1 above. 3. The Republic of South Africa and the State of Israel shall each, in accordance with their obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinian people, take all reasonable measures within their power to prevent genocide. 4. The State of Israel shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Palestinian people as a group protected by the Convention on the Prevention and Punishment of the Crime of Genocide, desist from the commission of any and all acts within the scope of Article 2 of the Convention, in particular, a. Killing members of the group, b. Causing serious bodily or mental harm to the members of the group, c. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and d. Imposing measures intended to prevent births within the group. 5. The State of Israel shall, pursuant to point 4c above, in relation to Palestinians, desist from and take all measures within its power, including the rescinding of relevant orders, of restrictions and or of prohibitions to prevent a. The expulsion and forced displacement from their homes, b. The deprivation of b1. Access to adequate food and water, b2. Access to humanitarian assistance, including access to adequate fuel, shelter, clothes, hygiene and sanitation, b3. Medical supplies and assistance, and c. The destruction of Palestinian life in Gaza. 6. The State of Israel shall, in relations to Palestinians, ensure that its military, as well as any irregular armed units or individuals which may be directed, supported, or otherwise influenced by it, and any organizations and persons which may be subject to its control, direction, or influence, do not commit any acts described in 4 and 5 above, or engage in direct and public incitement to commit genocide, conspiracy to commit genocide, attempt to commit genocide, or complicity in genocide. And insofar as they do engage therein, that steps are taken towards their punishment pursuant to Articles 1, 2, 3, and 4 of the Convention on the Prevention and Punishment of the Crime of Genocide. 7. The State of Israel shall take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 of the Convention on the Prevention and Punishment of the Crime of Genocide. To that end, the State of Israel shall not act to deny or otherwise to restrict access by fact-finding missions, international mandates and other bodies to Gaza to assist in ensuring the preservation and retention of said evidence. 8. The State of Israel shall submit a report to the Court on all measures taken to give effect to this order within 1 week, as from the date of this order, and thereafter at such regular intervals as the Court shall order, until a final decision on the case is rendered by the Court. 9. The State of Israel shall refrain from any action and shall ensure that no action is taken which might aggravate or extend the dispute before the Court or make it more difficult to resolve. End of quote.
I thank the Registrar. Immediately after the application containing the request for the indication of provisional measures was filed, the Deputy Registrar transmitted an original copy thereof to the Government of Israel. He also notified the Secretary General of the United Nations. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same article states that the Court shall proceed to a decision on the request as a matter of urgency. This imperative must, however, be balanced with the need to fix a date of oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings, during which they could present their observations on the request for the indication of provisional measures, had been fixed for Thursday, 11 January 2024 at 10 a.m. I would now like to welcome the delegations of South Africa and Israel, and I note the presence before the Court of the agents and counsel of both parties.